recording.
Hi, everyone. We are very honored that you can come to listen to our speech today. My name is Johan, but you can call me Christina, and here are my group members.
Hi, I'm Mitch.
Hi, I'm Ashley.
Our group's topic today is about copyright, and we will cover background, case study, salient points, and at the end with some discussion questions. Before we start, we would like to ask you two general questions about copyright. First, in the following, what types of work are copyrighted? Dramatic, literary, musical, graphical, speech, communication signals.
What would you mean by communication signals?
You have to think about it, and I can give you the answer later, but not right now.
Oh, okay. Well, I know that just about everything else would fall under copyright, I think, of those five. But I don't know about communication signals. But yeah, what are they? What are they? Tell me.
Okay, so the answer is actually all of them,
Oh,
but I will give you some of the examples later when we talk about copyright. And the second question is, why in the following what are not protected by copyright? Data, characters, slogans, themes, plots, and ideas.
hmm. Any thoughts, Ashley?
Um, what do you mean by data?
um like every data you saw online, and like you collecting those datas. Yeah,
Hmm,
like the general numbers datas.
I think that
Just don't overthink about it, just quick.
I think that characters wouldn't be protected by copyright.
Okay, so actually the answer is also all of them.
Hmm.
Huh, yeah. So from these two simple questions, we can see that copyright has an impact on many things we use in our daily life. So in the following times, we will take you to understand the copywriting in details. Let's start it. There are some background informations about the copyright before getting into the rest of the topic. So first, what is history and the main objectives of copyright? According to Government of Canada, the Canadian Copyright Act came into force in 1924. Then amendments were made in the following years until 1988 modernizations of the Copyright Act began. Canadian copyright laws and regulations are designed to ensure that the rights of the creators and other rights holders are recognized and protected, and to promote access to copyrighted works. Canada's domestic copyright frameworks must also meet our international obligations and be consistent with international standards endorsed by Canada. Effective copyright protection is key to cultural expression, citizen engagement, and economic growth powered by the rapid expansion of the knowledge based economy. So, what is copyright exactly? Copyright means the right to copy. And according to a government of Canada, copyright is the exclusive legal right to produce, reproduce, publish, or perform an original literary, artistic, dramatic, or musical work, or a substantial part of it. The creator is usually the copyright owner. People who want to copy or use the work, they generally have to ask for permission and or pay. However, the employer, for example, a film studio, may have copyright in the works created by employees, unless there is an agreement in place starting otherwise. According to the Act, the copyright owner has some general rules. Some general rights. The sole rights to produce or reproduce that work or a substantial part of it in any material form. The sole rights to perform the work or any substantial part of it in public. If the work uh, if if the work is unpublished, the rights to publish it or any substantial part of it, then we have to understand that there are 7 types of copyright are protected by copyrights. First, literary works, including books, pamphlets, computer programs, software, and other works consisting of text. Second, dramatic works, including motion picture films, plays, screenplays, and script. Third, musical works, including musical compositions with or without words. Fourth, artistic works, including paintings, drawings, maps, photographs, sculptures, and plans. Fifth, performances, meaning any of the following, including a performance of an artistic, dramatic, or musical work, recitation or reading of the literary works, and improvisation of a dramatic, musical, or literary work. Sixth, sound recordings, meaning recording consisting of sounds, whether or not a performance of the work, but not including any soundtrack of a cinematographic work, where it accompanies the cinematographic work. And the last one, communication signals, meaning radio waves transmitted through space without any artificial guide for reception by the public. That's communication signals, as I answered your questions.
Yes, it does.
Okay, so what are not protected by copyrights? For example, like ideas, facts, short and one-word titles, and works that are not fixed in the material form. Works have not been written down or recorded in somewhere permanent format are not protected by copyright. Additionally, work which are not original, which works whose creation did not involve the exercise of skills and judgment, cannot be protected by copyright law. You may be wondering how long it lasts and what happens when it ends or expired. Generally, copyright lasts for the life of the author and for 70 years following the end of the calendar year. The protection will expire at the end of the 70th year after the author dies. When it expires, works fall into the public domain and are free to be used and joined by anyone without the need to acquire permission. And there are several differences between copyrights, patents, and trademarks. Copyright, as we're talking before, I don't think I have to repeat it again. But like so what is patents? So patents covers new and useful invention, and or any new and useful improvement to an existing invention. And trademarks, maybe one or combination of a word, sounds, or designs used to distinguish the goods or services of any one person or organizations from those of others. As a teacher, we have to know the differences between copyright infringement and plagiarism. So, copyright infringement under the law covers many unlawful activities that violate the rights of the copyright holders. Copyright infringement is constructed under law as plagiarism is constructed under ethic. Plagiarism is essentially taking someone else's work and presenting it as your own, like when we writing essays or And I will pass on to my group members.
Colleague Mitch. Okay, so let's quickly talk about AI and copyright, especially since AI is going to be something that we as teachers are going to have to contend with, especially large language models like, say, ChatGPT. So, in the present and near future, these types of models are going to become a bigger part of the classroom, whether we like it or not. Personally, I don't like it, but we can't really stop kids from using it. So, despite the fact that these models are going to become a part of the classroom in some aspect or another, they can run afoul of copyright laws because they're often trained on copyrighted material. So, certainly, AI can go and paraphrase an idea and not cite a source for it, and that'd be plagiarism, but they can also go and wholesale copy a passage of text, for instance, and that is going to be a copyright infringement if the AI passes that text as its own, and if that is then submitted to a student, and then if that is then used by a teacher for something, that teacher is then doing copyright infringement, whether they know it or not. So, let's see there. So, it's already contentious. It's already going to be used to essentially have students not think about their own ideas. And we need to be careful if we ever encounter these types of AI models in case not only ideas are being copied essentially, but the text themselves. So, moving on to a case study real quick, let's talk about one of the latest big cases that has affected Canadian copyright laws, especially when it comes to teaching, and that is going to be the matter of photocopying textbooks. This case study is the Alberta Education v. Canadian Copyright Licensing Agency, Access Copyright, which was essentially Alberta Education is essentially a whole coalition of school boards and education ministries across the country, while Canadian Copyright Licensing Agency is a group of copyright agencies. So this is a 2012 decision by the Supreme Court of Canada. The original case was brought forward by copyright agencies over teachers photocopying parts of textbooks for student uses. These agencies sought to revise the tariff system to include any copied excerpts. So if you were to copy, say, a paragraph from a textbook, then the school would have to pay for 2 textbooks worth of tariffs, essentially, for royalties to use this textbook. So that a group of teachers, a group of the education ministries opposed this and brought it to court. So they eventually appealed to the Supreme Court, where it fell under whether or not photocopies would become fair dealings or not. So the outcome of this, it was a 5-4 split in the Supreme Court. The majority ruled in favor of the Education Coalition regarding the 6 factors of whether photocopies are considered fair dealings, since fair dealings is a 2-step process. So first step is figuring out if the purpose is justifiable by the user. In this case, can the student go and justify why they need a photocopy? And no one really disputed that, yes, this is something that the students need. They need access to this information. What was really contentious here was how this information was acquired through the teacher. So afterwards, the Supreme Court looked at the 6 factors, which are purpose, character, amount, nature, effect, and alternatives to the dealing. So the 4 ones that they focused on were purpose, which they concluded that teachers share a symbolic relationship, facilitating student research. Also, they noted that private study, which does fall under fair dealings, means any non-commercial study, even if it's not isolated. So if you're studying with a group of friends, that is still considered public or private study. If you're studying with a whole class, that is still considered private study. The next one they used was the amount of work. So since teachers do not act independent of students when copywriting, it's the same as purpose. It's that same symbolic relationship. And the amount they also conclude that the amount is the percentage of original work copied, not the number of copies made, as was claimed by the Copyright Agency in the original suit. Next, they figured the alternatives. The Copyright Agency claimed that essentially for every new student, the school could buy a new textbook, which is true. They could buy a new textbook, but that simply wasn't feasible that economically. So the court ruled that no, schools couldn't simply do that, and that having the copyrights still counted as essentially an alternative, a justified alternative. Next is the effects. So the Copyright Agency claimed that because these teachers were copying all their textbooks, this was causing a plummet in the sales of textbooks. And certainly sales had dropped by 20%, but there's no way that they could determine that this copying was a factor in that drop in sales. So the court ruled against them with that as well, saying that there's no connection between their drop in sales and the photocopying. Interestingly enough, even though the minority, the 4 judges that disagreed with the majority opinion, disagreed with the purpose, amount, and alternative rulings, for effect, they all agreed that there is no financial issues here. All right, then. I shall turn it over to Ashley.
Okay, so I'll talk about the salient points in relation to our teaching degree and future as teachers. So the first point is about copyright law. Teachers should have a basic understanding of copyright law. They should also be aware of the consequences of copyright infringement. So copyright infringement can lead to legal consequences, including fines and damage to the professional reputation. So teachers must be mindful of how they use copyrighted materials in their classroom, ensuring that they adhere to the fair dealing provisions and seek necessary permissions for uses beyond these limits. The next one is educational exceptions and fair dealing. So copyright law includes exceptions allowing teachers to use copyrighted material for educational purposes under fair dealing, which was already discussed earlier. So fair dealing is a crucial concept for teachers, providing them with the legal framework to use copyrighted materials for educational purpose without infringing on the rights of creators. So teachers can produce, communicate, and display short excerpts of work for purposes such as research, private study, criticism, review, news reporting, and education. This allows educators to enhance their teaching with diverse resources while respecting copyright laws. Similarly, the attribution of citations. Teachers must cite work used and should emphasize the attribution and citation of works to their students to avoid plagiarism, which is already discussed earlier as well. This protects the teachers and the school from any legal issues and helps role model the correct use of copyrighted material to students. And for our next point, I'll discuss plagiarism. So teachers should instill in their students an understanding of plagiarism and its consequences. Teachers must emphasize the importance of originality and proper attribution in all student work, helping students understand that presenting someone else's ideas or words as their own is both unethical and academically dishonest. Educators should teach students how to properly cite sources, use quotation marks for direct quotes, and paraphrase. By fostering a culture of honesty and respect for intellectual property, teachers can guide students in developing their own ideas and voices. As well, teachers should use tools and techniques to detect and address plagiarism, which is good to know because with the rise of like ChatGPT and AI, plagiarism is often used a lot with students with AI. And then for the next one is digital citizenship. So for teachers, digital citizenship involves guiding students to use technology responsibly and ethically while modeling these behaviors themselves. Teachers play a crucial role in educating students about the importance of online privacy, security, and respectful communication. And like I just said, they need to know how to use ChatGPT and things like that as well. And then for the next one, students can create work that is protected by copyright. So all student work is protected by copyright and needs permission for use. Canadian copyright law grants creators exclusive rights over their works, ensuring that they receive recognition and financial benefits. By learning about copyright, students need to become aware of the importance of attribution, attributing sources correctly, adhering to the fair dealing provisions, and seeking permission when necessary. And this knowledge helps students avoid plagiarism and also respect creators' rights. And then for the last one, I'll discuss schools. So, schools and school boards often have specific policies regarding the use of copyrighted materials. Many educational institutions have licenses for certain resources, such as digital databases, ebooks, software, and things like that. So, for example, school libraries are protected by the right to utilize copyrighted material. They are able to make copies for cataloging, restoration, and they can also use digital technology to deliver an interlibrary loan copy of copyrighted works to students. Teachers should know which materials are covered and the terms of use. For example, school libraries are protected by the right to utilize copyrighted materials. Similarly, a school's use of live or recorded music requires permission or payment for school events on school premises and while people are on hold on the school phone. A teacher's compliance with the copyright policies protects the school from potential lawsuits and financial liabilities. And then for our discussion questions, we have 3 questions here. The first one is, in what ways could copyright restrictions enhance or hinder a teacher's ability to deliver high-quality education? Our second one is, how do you foresee the role of copyright evolving in education with the rise of digital learning platforms? And how do you handle situations where students unknowingly violate copyright laws in their projects or assignments? And then the third one is a scenario that I actually encountered in my pre-service teacher. I'm tutoring right now in a school. So this scenario is where a student in one of the teacher's grade 9 ELA classroom that I work with, they submitted an essay for the class, and the teacher suspected plagiarism and the use of ChatGPT. And after using a plagiarism check tool, it showed that the student plagiarized 60% of the assignment, yet the student denied using it. So my question would be, what would the teacher do in this situation? And what are the ethical and legal considerations here?
Hmm. Well, we got 5 minutes until 30 minutes, so we can discuss these, I think.
Yeah.
So,
What do you
for,
think?
for question 3, like, especially, I feel like there's there are certain cases where, like, the plagiarism checker
Mhm.
might not be correct, but also if it's 60%, if it's like a fairly decent amount, then you should be asking your you should be checking, even if it's like plugging the question that you gave them into a chat gpt and seeing if something similar comes out.
Mhm.
So I'd say that the teacher should ask that they rewrite it, because especially if they can determine where where the plagiarized work comes from, and they can say, okay, this exact passage appears in this textbook, and you either copied it without giving it a citation, and you need to give it a citation, and there's so much of it that there's no original ideas here. So I do feel that the teacher would need to simply say that, yes, you need to redo this. There's too much evidence against you.
Yeah.
Yeah, I feel the same because like one of my friend is doing an essay before, but like she write it exactly like by her own. But like when she's doing a pre-plagiarism or a AI checking, and it said is 80% by yeah, yeah, the tool said is 80%
Mm-hmm.
plagiarism or something. So it shows that the tool is not exactly right,
Mhm.
and you have to make sure that, as you said, you really saw one of the sentence or a lot of it were 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 really copied it,
Mm-hmm.
and you know, generally the ChatGPT is also a machine brain,
Mhm.
so you might, as a person, you might also have a same idea as a ChatGPT. So mm, it's really hard. But we have a lot of tools you can use, but not just focusing on one tools. Maybe just check a lot of it. Maybe different tools will give you different answers.
Mhm.
Yeah, I will say as well, another thing that you can do is, if the student does have did on, say, a Google Doc or something, you can go and look back at the editing history of that Google Doc. If
Hmm.
if suddenly like 2,000 words appear at once, then there's something suspicious there.
Mhm.
But if it follows the general, like, okay, you can see the student typing it out in the history, you can see them making edits, backspacing, and changing wordings and such, then yes, there's that's probably means that, okay, they're fine. But again, if it suddenly appears and they make no other changes, then they got it from somewhere.
Mhm. Yeah, I totally agree with both of you guys. And in this situation, the teacher did get the student to rewrite the essay. So,
Mm.
yeah, and I guess considering like the ethical considerations for this, I guess like an issue would be like, do you trust the student or do you not trust the student? And then there's an issue of like the student, like if you don't trust the student that says that they didn't use ChatGPT, then that student might not trust you. So that that's why the teacher was a little bit like concerned, and she went around and asked people like, what would you do in this situation? But yeah, I think like the best way to get around a situation like this would just be to like talk with the student and say like, hey, you're just gonna have to redo it, sorry. Like, I don't know.
But
Yeah,
like redo it is really a good choice
yeah.
because it also related to the second question. I feel like because like if a student is unknowingly violated a copyright law um or like plagiarism or forgot to do a citation or something. So like one of my friend is like is also a for of a international student.
Mhm.
So what she did is she wrote it by her own, but in her mother tongue, and then use a Google Translator to translate it into English. But like she doesn't know that one of the sentence that she wrote it was coming and translated by Google Doc was coming from another book.
Oh, okay.
Yeah, because like the Google Translator will use some of a sentence that she can that the Google can access it and translate it into your into English, and so that that professor just did not let her rewrite it and said you I think you're plagiarism, and she didn't allow her to rewrite or do anything, just and didn't give her any points on that assignment.
Yeah, that's tough.
Mhm.
And what about for the other questions? What do you guys think?
Well, for question one, I think actually that copyright is a bit too restrictive for teachers. Like, I feel that for teachers, since we are educators, since we are doing education, at least it can be assumed we're doing education. As long as there's no financial component, as long as we're not, say, making a profit out of copying textbooks, for instance, I feel that copyright shouldn't be an issue for us.
Mhm.
Like, we should be able to use what we need to give an education as long as we've acquired it legally, as long as it's all that's fine, and as long as we aren't making a profit off of it.
For sure.
Other than that, everything should be a-okay. Because even looking back at the case study with all the judges agreeing that, yeah, there was no financial issue with photocopying these textbooks since they weren't being sold, they're just used for student use, for education, for private study, is what they eventually concluded. So I
Mhm.
feel that should set a little precedent for just about everything else.
Mhm.
Yeah.
For sure. Yeah.
And oh, you go first.
Oh, I was just gonna say I agree with what you say.
Oh, yeah, and I think as we said in the present in the speech, we know that the copyright is the basic information about copyright and how the Copyright Act is work is really important for teachers. But like I feel like the most important for teachers is to let students not to do the plagiarism, because if they did it, then it refers to you, said, oh, you use this book and you violate the Copyright Act, and the student did what you did, and they didn't cited those books that you photographed or like scanned. That would be really bad.
Yeah, exactly. For sure.
All right then. So, I guess that about wraps it up. Any final thoughts from anyone?
No, I'll just skip to our last slide here. So these are our references here. And yeah, thank
And
you.
thank you, Guy. Thank you so much for listening.
Yeah, thank you everyone, and that shall be it.